Public Order Act. Public Order Act 1986, (serious disruption to the life of the community), regulations 2023. Lord Sharp of Epsom.
My Lords, I would like to thank all noble Lords for attending this debate. These regulations amend sections 12 and 14 of the Public Order Act 1986, which grant the police the power to place necessary conditions on public processions and assemblies to prevent specific harms from occurring. One of these harms is serious disruption to the life of the community. These regulations do not create new powers, but they define this harm. Once in force, these regulations will ensure that public order legislation is clear, consistent and current. They will carry over a definition of serious disruption which has already been approved by Parliament and provide greater clarity on the circumstances in which the police can exercise their powers to manage public processions and assemblies. Most importantly, they have given the House of Commons the opportunity to consider these measures. Without these changes, there is potential for confusion over what is the lawful extent of protest activity. The police and public will have to grapple with one threshold for criminal offences in the new Public Order Act and another for the use of discretionary police powers in the 1986 Act. With these changes, it will be easier for all to understand when disruption from a protest is no longer legitimate. The provisions in these regulations are broadly similar to those brought to the Public Order Act 2023 as a government amendment during its passage through Parliament. The only difference is that these regulations do not allow the police to place blanket conditions on multiple protests. I will detail exactly what the regulations do shortly. The government amendment was narrowly defeated by 14 votes in this House and was not considered by the elected chamber. This vote occurred before the vote for adopting the current definition of serious disruption in the 2023 Act, which was approved by both chambers. As both houses have agreed on a definition, we are sensibly extending it across the statute book and bringing further clarity to public order law. That is something which has been sought by senior police officers and many in this chamber today. The Commissioner of the Metropolitan Police Service has said, and I quote, "The lack of clarity in the legislation and the increasing complexity of the case law the case law is making between that right to protest and the rights of others to go about their daily lives free from serious disruption more difficult and more contested." The delegated power being used existed prior to the introduction of the Public Order Act 2023. The power was available for the government to use during the passage of the Public Order Act of 2023. These delegated powers were scrutinised by the Delegated Powers and Regulatory Reform Committee, who recommended that a definition of serious disruption to the life of the community be included on the face of the Police, Crime, Sentencing and Courts Act 2022, coupled with the power to amend the definition by affirmative procedure regulations. This recommendation was accepted and implemented in full. It is entirely right that the Executive uses powers conferred by both Houses of Parliament to allow the elected chamber to consider the proposed change in law. The other place has now had the opportunity to consider these measures and have approved them following debate on the floor of the House, which it did yesterday. Baroness Jones's motion is highly unusual and seeks to strike down legislation passed by the elected House and undermine sensible changes which bring clarity and consistency to the law. During the passage of the Public Order Act, the Government has listened and responded to the strength of feeling from Parliament on many issues. Changes were made on many of those issues, including serious disruption prevention orders, protections for journalists reporting on protests and others. The need for clear powers to improve the management of highly disruptive protests has been well rehearsed, but I will reiterate them quickly. The current Just Stop Oil Slow Walk campaign has resulted in the use of over 13,770 police officer shifts, diverting police attention away from local communities. Financially, this has cost the taxpayer £4.5 million in just 6 weeks, and this is in addition to the £14.5 million it cost last year. These near daily protests, and as of yesterday I think it was 156 separate protests in 6 weeks, have pushed the public to their limit. We've seen people taking matters into their own hands. Therefore, as a government, we must do what we can to empower the police to respond swiftly and effectively. Given the scale and impact of the disruption caused by slow walks and sit-ins on roads, it is in the public interest to clarify these police powers as a matter of urgency. The government has always been clear that the delegated powers were needed to be able to respond quickly to evolving protest tactics. The intensive use of slow walks across London has proven that. Once enforced, the regulations will provide the police with the legal clarity they need to protect the public from this tactic. As I've already mentioned, these regulations do not grant new powers to the police, but clarify the extent of existing ones. Therefore, it was deemed disproportionate to carry out a full public consultation. Targeted engagement with the National Police Chiefs Council, the Metropolitan Police Service, and other police forces was the appropriate approach. All have welcomed clarity in the law. The Metropolitan Police Service specifically welcomed clarity as to how the police should consider serious disruption in relation to imposing conditions. And the regulations achieve this by making the following clarifications. Firstly, these regulations will clarify that the police may consider the cumulative impact of concurrent and repeated protests in the same area when assessing whether serious disruption to the life of the community may occur. Although a single protest may not in itself cause serious disruption, it is undeniable that a community subjected to repeated or concurrent protests will suffer due to the compounding effect of multiple protests. Secondly, they allow the police to consider the absolute disruption caused by a protest. That is to say, police should be able to consider the disruption a protest may cause regardless of what disruption may be common in an area for other unrelated reasons. Without these regulations, serious disruption to the life of the community is often considered with reference to what is regarded as normal for a given area, rather than the nature of the disruption caused at that moment in time. Thirdly, the regulations define the term community to mean any group of persons affected by the procession or assembly, and not just those who live or work in the vicinity of that procession or assembly. This change clarifies that a broader definition of community is to be used when interpreting the meaning of serious disruption to the life of the community, and this definition better reflects the modern way of life in major cities. And finally, as I've previously mentioned, the instrument aligns the definition of serious disruption with that in the Public Order Act 2023, simplifying protest law. During the passage of the Public Order Act, the appropriate definition of serious disruption was debated at length. I would again like to thank all noble lords for what was an exceptional debate with high calibre contributions from all sides. I remain of the view that the definition rooted in protest case law proposed by the noble and learned Lord Hope strikes the right balance between legitimate and illegitimate protest. This definition has been scrutinised and approved by both Houses of Parliament, and it should now be carried across to the Public Order Act 1986 to ensure consistency across the statute book. As well as aligning public order legislation, they also bring further clarity by building on the non-exhaustive list of examples of serious disruption to the life of the community to include the prevention of or hindrance that is more than minor to the carrying out of day-to-day activities such as making a journey. This provides legal clarity that is entirely appropriate for the police to place necessary conditions on protests that are obstructing the public from going about their daily business. And finally, I would like to remind the House that the Government is legally required to publish a report on the operation of amendments made to sections 12 and 14 of the Public Order Act 1986 by the Police, Crime and Sentencing and Courts Act of 2022. The report must be published and laid before Parliament by the 28th of June 2024. I can confirm that this paper will also report on the operation of the changes made by this statutory instrument. In summary, the regulations are necessary changes to the law to ensure public order legislation is clear, consistent and current. They will improve the protection of the public, who this government supports, against the minority of protesters who repeatedly trample on their rights. Current and former police officers, as well as peers and members of the other place on both sides of the debate, have called for public order legislation to be both easy for officers to interpret and to be specific. This statutory instrument achieves these objectives, and I beg to move.
Question is that this motion be agreed to. Amendment, Lord Coker.
My Lords, can I just make a brief statement before we start, or I start my remarks? As a Nottinghamshire resident, a former Nottinghamshire Member of Parliament, with an obvious close attachment to the city, can I say how shocked, appalled and saddened I am at the awful events in Nottingham earlier today, as we all will be. I'm sure the whole House will want to join with me in thanking the emergency services and sending our condolences to the families and friends of the victims, indeed the whole community. My Lords, I beg to move the regret motion in my name on the order paper. There were contentious debates, furious debates over this Act in the Chamber and beyond, although you wouldn't have recognised that from the Minister's comments. And let me spell out from the beginning, I don't defend, neither does my party defend the actions of Just Stop Oil for 1 minute. I think they've gone beyond the bounds of reasonableness. But I do believe that the police have the powers to deal with these protests if they had the confidence to use them. Indeed, I agree with the Chief Constable of Greater Manchester, who said in the media just a couple of weeks ago, we have the powers to act and we should do so quickly. So our message to the police should be use the powers you have and you have our support. We have the regulations before us which make very real changes to the public order legislation we have. It reduces the threshold for the policing of protests to prevent serious disruption for the life of a community from significant and prolonged to more than minor, and refers to the cumulative impact of repeated protests. I would remind the Minister and noble lords that I did ask in the passage of the Public Order Bill, as it was then, whether the government intended to use secondary legislation to overcome the fact that it had lost its vote on measures that were introduced without the noble lord knowing a thing about it, with the amendment introduced into the Lords, which no doubt the noble lord found out about like the rest of us when it was on the radio in the morning. But I asked him specifically, and I quote from Hanside on the 14th of March, where the Minister said they do not permit this or any future government to make changes to the meaning of serious disruption in this bill. My contention is that that statement implied that the government would not, in any circumstance, bring forward secondary legislation to change primary legislation. Changes to this law presented to this Parliament via secondary legislation, which I would remind my lords is unamendable. No ability for meaningful debate. And my lords, all protests could be properly and duly effected across the country. No opportunity for anyone in this chamber or indeed the other place to say these protests these changes go too far. No ability to debate whether these changes would impact on protests that, although we don't like Stop the Oil, we might support protests which deal with extensive housing development or inappropriate third runways at Heathrow Airport by lying down in front of bulldozers, or by protests against new nuclear power stations and so on. All of these protests potentially affected by the changes to the legislation that the government has brought forward. No opportunity for us to put amendments to change that. And the government minister just dismisses that as somehow irrelevant. And my lords, all done without proper consultation. An appalling explanatory memorandum only changed today to try to take account of the criticisms in the 38th report of the Secondary Legislation Committee, which absolutely eviscerates the government and what it's done. I received an email, I don't know whether anybody else received this, saying that the government was changing its explanatory memorandum at 2:27 today. 2:27 I had an email. Later today, the House is debating the public order draft, etc. The Home Office has just laid a revised memorandum to these regulations. Honestly, you couldn't make it up. 2:27, my lords. I don't know whether all noble lords will be aware of the extensive publication of this change. Why on earth does the Minister think that's acceptable, in particular in the way that it justifies itself in answer to the criticisms of the Secondary Legislation Committee? I'll tell you, of course.
I haven't seen the additional explanatory memorandum. Would the noble lord tell us what additional material is in it? And if it is substantial, then surely it should be provided to all members of this House before the debate proceeds.
I'll read a couple of the sentences from it. Para 6.8 provides a reason why the measures are being brought back in this instrument. The justification to promote consistency across the statute book is similar to that provided to the SLSC in advance of the report and is discussed at paras 16 and 18 of the report. I couldn't quote what paras 16 and 18 actually are. New para 10.1 provides a reason why a full consultation was not necessary. I have no idea what para 10.1 says, so I apologise to the noble lord. And so it goes on. So the government seeks to justify itself.
sorry to interrupt my noble friend in full flow, but I'm shocked by what he's saying. Could he just confirm that this change to the explanatory memorandum was therefore tabled after the House of Commons had their debate?
Well, my noble friend predicts what I was going to say next. In a calm, reasonable, rational way, I was going to point out whether the Minister could confirm that the other places considered these changes to the explanatory memorandum before it's had the opportunity to consider the new or the changes made to the explanatory memorandum. I tell you, my lords, as a football fan, if this was a football terrace or a football crowd, they'd be chanting to the government they don't know what they're doing, and I think they would be quite right. At its heart, what do we believe, as well as the changes made to this? I tell you what I think, and I tell you what I think the SC said, and I think what many noble lords said. It is an absolute fundamental constitutional outrage what is actually taken place. My lords, this House defeated these or similar proposals brought forward in a panic, as I said, by Lord Sharp, without knowing really that he was have to do it early this year. Primary legislation was defeated. So what does the government do? It doesn't bring forward new primary legislation. It tries to sneak through in an underhand way secondary legislation without proper public consultation. As the Secondary Legislation Committee says, we are not aware, my lords, and this is a quote from the report, we are not aware of any examples of this approach being taken in the past. We are not aware of any examples of this approach being taken in the past. Is this what it's come to? So this government, our government, has, in a shocking betrayal of our unwritten constitution, undermined the conventions on which our way of doing things is based, the way in which our parliament is based. How many times have I stood here and spoken of the need to protect conventions, to recognise the right way of doing things? These conventions protect our democracy, protect our rights, protect our freedoms. They're not just something for the government of the day to dismiss because they're inconvenient. They undermine the workings of our parliamentary democracy, and as such, it is shocking. Of course the elected government should have its way, but this was not passed by the other house before being defeated. The Minister says in a piece of political theatre, well, don't worry, he passed it yesterday in the House of Commons, embarrassed and in a panic and in the face of today's criticism, so they could say, well, don't worry about that, we could be able to sell coca and everybody else who's mentioned it, we passed it yesterday through secondary legislation. So that completely torpedoes their argument that the House of Commons hasn't discussed it. But such is the rush, my lords, such is the rush. They can't even ensure that an amended explanatory memorandum is put before the other place before it decides on the legislation before them. Honestly, it is. I have, like many noble lords, been in this place for a number of years, and I have never seen anything. But nothing changes. The fundamental principle that this government is using secondary legislation to overcome primary legislations. So, my lords, hence my regret motion in deploring it and calling on the government to think again. We will abstain, as I say, on the fatal motion. We will not block this legislation. So let me be clear to those who keep asking me whether the official Labour position, His Majesty's opposition position, is to block the bill. We will not do that. I understand why some people would wish that to be otherwise, but as His Majesty's opposition, we will respect convention. We will respect tradition. We will respect the right way of doing politics in our country. And I don't believe that it necessarily shows any respect for the way that democracy votes by voting down the opinion of the elected government of the day. The way to change that is, in my view, at the next election, to get rid of this government and put another government in its place. That is the way forward. We've opposed these measures and will continue to argue they are necessary, but we should not, in my view, be debating this amongst ourselves. The true adversary in all of this is a bankrupt government turning in on itself. If the government doesn't, we will respect the right way of doing things. So if we are to be the next government, we will expect those who may oppose us then to act in the proper way, respecting the will of the elected House, which is what I'm saying to this government, that they are not respecting the traditions of our country. It is a sign of His Majesty's opposition doing all it can to prepare for government, to look like a government in waiting. This shoddy piece of constitutional, disrespectful piece of legislation put forward no consultation, shows how far this government has fallen. It is a moral and constitutional outrage of which the government should be ashamed.
Yeah. The original question was that the motion be agreed to. Since when an amendment has been moved to leave out all the words after that and insert the words as printed on the order paper. The question I therefore have to put is that the amendment in the name of Lord Coker be agreed to.
For the situation in which your lordships found yourselves this evening, because I've devised this formula, no more the formula which has been quoted in the regulations before us. I drafted that particular formula with very specific reference to the locking on and tunnelling offences which are described in the bill we were considering at that time. I have to confess I wasn't looking forward at that time to any other use of that formula, and of course I understand why the government have found it attractive, and I understand the point they're making, that it's better to have a uniform test right across the board. But, my lords, as the noble Lord Coker has been saying, this is a debate about the right way of doing things. Yes. And I have been making strenuous efforts in the IUL bill to make it clear that parliamentary accountability requires debate in the chamber on things that we can discuss and amend if necessary, and not be driven by statutory instrument. So, Lords, while I stand by the formula which I devised, and I believe it's the right formula, it puts the point at exactly the right point for the police to decide when they should intervene. I deeply regret that the government have felt it necessary to approach the situation in this way, and I endorse exactly what the noble Lord Coker has been saying. And therefore, I wish to make it clear that while I stand by my formula, I greatly regret the procedure that is being adopted.
I actually told the noble and learned Lord Hope of Craighead that he should not have helped the government, but I'm prepared to forgive him. From a sense of generosity, because I know he was trying to help, but actually it didn't actually help at all. Now, this opening speech by the Minister is quite interesting because it lasted nearly 9 minutes and it focused almost entirely on the what the police were going to do and what the protesters were going to do, and it avoided the talk of the constitutional novelty that the government has actually introduced. And for me, this is a make or break moment for democracy. It's a crossroads that we really have to face up to, because in spite of what the noble Lord Coker was saying about respecting conventions, the fact is the government has not respected our conventions. So there are two issues at stake here. First, a suppression of freedom with a measure that your Lordship's House rejected as unreasonable only very recently. And in some ways more seriously, secondly, a government move that sets a precedent that the government can use secondary legislation to overrule Parliament's will as expressed in votes in primary legislation. Now, this means that any future minister at any time could decide to change any law in any way. Now, this to me is deeply, deeply disturbing. And I think that we are going to perhaps hear from other people, I hope, who find it disturbing as well. Now, the Shadow Attorney General has said that we have to stick to the conventions and allow this statutory instrument to pass. But that argument seems to be based on a fundamental misunderstanding of the conventions. By convention, your Lordship's House does not block primary legislation, but this isn't primary legislation. Your Lordship's House can and does and has blocked statutory instruments. I recognise that there's no convention that the government cannot use a statutory instrument to overturn parliamentary votes on primary legislation, but that convention doesn't exist because no government has ever tried to do this before. What we're facing here is a novel issue, a turning point for our parliamentary democracy, and the decision in your Lordship's House on the following question will establish a new constitutional understanding. The key question is, should the government be allowed to overturn parliamentary votes on primary legislation by using secondary legislation? That's the question that we have to think about here today. We've talked before in your Lordship's House about our discontent about overreach by secondary legislation. And I just ask you, is this not the day to act on this? And if we refuse to act today, when are we going to act? The Labour Party has tabled a motion to regret, and regret is what I believe we'll all experience in the future if we fail to support this fatal motion today. The whole country will have cause to regret the further erosion of the right to protest, which is part of our basic British way of life, and the enfeebling of this House, which many in this House might regret as well. We will regret it when the ministers regularly start to use their power under secondary legislation to overturn existing laws that Parliament has debated and voted for. We will regret it when we read the headlines about the police arresting a group of parents and their children while protesting about pollution outside their school. And what about the people, the community up in Stone in Staffordshire, just the last week, who protested about having HS2 HGVs rushing past their houses 42 times a day? They protested quite hard, and I think actually they would have fallen foul from this particular piece of law. Or arresting people holding a vigil for a victim of police violence, which of course has happened. We will definitely regret it when we hear about a big march against a government policy, as when 1 million of us protested about the Iraq War, and the police then have to say, sorry, that protest is banned because it may cause more than minor disruption. That's a very low bar. This is an authoritarian law that hands power to decide what is a good protest or a bad protest over to the police and the Home Office. It erodes the rule of law because any protest will now be permitted only at the discretion of the police, rather than being a fundamental right that can be interfered with only in limited and proportionate circumstances. And it's being enacted in an authoritarian manner by ministerial decree. If we let the government overturn votes by ministerial decree, then what is the point of this House and all our work? And if the justification for allowing the government to act in this way is that your Lordship's House is not elected, then who is left to defend Parliament and the UK's uncodified constitution against encroachment by an out-of-control government? This isn't a one-off. It's part of a trend of legislation that undermines parliamentary democracy. In the last 4 years, we've seen a whole series of skeleton bills pass through Parliament that hand over powers and discretion to ministers to make decisions with minimal parliamentary scrutiny. These bills that hand over the power to ministers to make and amend rules and laws have become the norm. It means that in recent years, we've seen a major shift in power away from Parliament, giving it instead to Whitehall. If the government are allowed to do this today, then the precedent will be set. They will do it again next month, and then the next government will do it as well. And parliamentary democracy will seep away until this House is less than a talking shop. In a few days, more than 55,000 people signed a petition that I put out against this legislation. That's a huge number in a brief time, especially on something that appears to be so technical and so small. But the regret motion misses the seriousness of the issues before us and the consequences of allowing this law to pass. If Labour and Lib Dems and Greens and sympathetic crossbenchers and even principled sympathetic Conservatives, we could beat this, we could defeat it. Yep. It is possible. Yep. Your Lordship has the power, we have the right and the constitutional duty to stop this statutory instrument, which is an assault on democracy. And if not now, when?
Here.
I rise to speak in my capacity as chair of the Secondary Legislation Scrutiny Committee, and the Noble Lord Coker already referred to the report we have published on the regulations that we're debating today. Now, in our report, we did raise a number of issues. First and foremost, we wanted to alert the House to the fact that this instrument did, as the Noble Learned Lord Hope has referred to, it brings back a measure which was rejected by the House during the passage of the Public Order Bill. A point we felt was particularly important because, regrettably, it had not been mentioned in the explanatory memorandum laid at the same time as the instrument itself. Now, it cannot be denied that primary legislation receives more thorough scrutiny than secondary legislation. And where a measure is rejected during the passage of a bill only for it to reappear in secondary legislation, we had no doubt that the House would want to be made aware of it. We concluded in our report that the House would probably wish to consider the possible constitutional issues that arise, and also to decide whether or not it wished to retain its earlier view on the measures. Now, my lords, we are an advisory committee only. We cannot tell this House what to do. Our role is to highlight matters about which we believe the House may want to challenge ministers and ask for explanations. And I think the debate today demonstrates how true it is that the House is concerned to debate these regulations thoroughly. Now, it's also a testament to the sterling work of the team which supports the Secondary Legislation Scrutiny Committee that the committee has been able to contribute to this important debate, and that my officials spotted this and questioned the government department about it as thoroughly as they then did, with further developments today, to which I'll refer in just one moment. But these regulations are not only significant in their own right, but they do illustrate issues of greater concern to those who sit on our committee. In May, we published our interim report on the work of the committee, in which we made observations on the instruments laid during the previous 12 months, and I pay tribute to my predecessor, my noble friend Lord Hodgson of Astley Abbots, who identified with me a range of matters to which our committee agreed. One was the inadequacy of consultation. And we set out examples in that report where inadequate consultation had had the effect of undermining the operation of an instrument. In our report on the regulations which we're now debating, we were also critical of the level of consultation, arguing that a considerably greater degree of consultation would have been more appropriate given the specific history, the range of interested parties, and the strength of views. Above all, these regulations demonstrate the committee's major and recurring concern that all too often the quality of the explanatory material accompanying secondary legislation is found wanting. As I mentioned, our report on these regulations criticised the explanatory memorandum because it failed to mention the measures had been defeated in the House on an earlier occasion, and as a corollary of that omission, also failed to explain the reasons why the Home Office takes the view that it should make a second attempt in this matter. This was important information that should have been included and provides more than ample evidence of the finding in our interim report that poor quality explanation was the most unwelcome feature of the secondary legislation which has been laid in the last 12 months. Now, just today, in the early hours, the Home Office laid a revised explanatory memorandum for these regulations, responding to some of the points in the committee's report. Now, the House can form its own view on whether the revisions address our criticisms. It's not for us to publish any further commentary. However, departments should not have to revise explanatory material at our prompting. The original version should always provide sufficient information to scrutinise the instrument fully. My Lords, in that interim report, we urged all government departments to strengthen their quality assurance systems so that explanatory material in support, in particular of secondary legislation, is clear, accessible and comprehensive. We will do our best to remain vigilant in identifying when departments fail to do this, and committed to drawing your Lordship's attention, as on this occasion, to instruments where the quality of explanatory material has fallen significantly short of the standard which I believe this House has a right to expect.
Address the public order issues. It's a fairly simple issue, really. It's not the role, and it can never be the role, of the unelected House to seek to have the last word. The last word on every issue belongs in the elected House. Sometimes they have to wait a year if the Parliament Act is used, it's true. But at the end of the day, they've got to be in a position of owning what they've passed, so the electorate can make the view about what they have done. That's where the government's formed, not here. So there's a simple issue, really. Our conventions have been tested. They've been found wanting, and I agree very much with the speech we've just heard. And simply because I'm a member of delegated powers, but that's not the issue. We've got case after case of the government taking away powers from Parliament to give executive authority to ministers. The House has debated it 2 or 3 times. So far, we haven't done much about it. But the simple issue is this, as far as this is concerned. The elected House has got to own the decision. And I have to say, at the end of the evening, I'm going to upset a few people, and I'm happy to vote for the motion moved by my noble friend. But if the fatal motion's put, I intend to vote with the government. Because I'm not going to be in a position, after the next election, of allowing the then opposition to claim, when issues arise, well, you never voted against it. I'm going to have at least one name in the lobby. This has happened before. This is not the first time. We've got cases, of course, of Lord Strathclyde in opposition, voting against fatal motions. We know it's been reviewed. It's maybe time to look at our conventions. The last time they were reviewed properly, I think, was 2006, with a joint committee chaired by my noble friend Lord Cunningham-Felling. But the fact of the matter is, I'm not going to get confused here, and I don't think I agreed with about 2 sentences of Lady Jones's speech on the constitutional issues, but she spent all week on social media misleading the public about the powers in Parliament. They belong... I'll give way to you. The powers belong to the elected House. They must be in a position of having the last word on every issue. As I mentioned earlier, I'll give way.
Can you tell me how I misled anyone? Because I actually think it's been the Labour Party who has misled.
Come on.
That's nonsense.
Anyone can look at what's been happening this week. It's been misleading. The fact is, we're in a democracy, we're an unelected House. Our job's very simple. We just ask the other place to look at things again and again and again. But at the end of the day, they have to own the decision. How can they go to the public at a general election if they've got decisions they can't own? Now, that's our present system. Nobody's come up with a plan for changing it at the present time.
motions before the House. The motion tabled by Lord Coker and the motion tabled by Baroness Jones. And I do so because, as Lord Coker said, this is a constitutional outrage. And I take that position even though I have great sympathy with the government's position in relation to the substance of these regulations. I think the government are absolutely right to say that those who demonstrate are not entitled to inflict more than a minor hindrance or delay to those who are going about their business, their daily business. And whatever the merits for which the demonstration is held, protesters do need to recognise that their right to freedom of expression, their right to freedom of assembly, are not the only rights in play. And Baroness Jones says this is an authoritarian law. Well, it's not. Members of the community have the right to get to work, to take their children to school, to attend hospital appointments without being caught in a traffic jam caused by protesters sitting in a road or walking slowly along a road with the very purpose of disrupting the lives of other people. That is simply outrageous. But that's not the issue tonight. The issue tonight is whether we are going to approve regulations which defy the will of Parliament as expressed by this House when we voted down on the 7th of February Amendment 48 of the Public Order Bill. Now, the Public Order Act, and Amendment 49 was not moved in the light of that. And I voted with the government on Amendment 48, and I was in the minority. And the government are now bringing forward, as we've heard, regulations to achieve exactly the same objective. And it's all very well, if I may very respectfully say so, it's all very well for Lord Rooker to talk about the other place being the dominant house, which they are, and that we must give way to them, but not when there is a constitutional outrage, not when, as we all know, scrutiny of regulations is cursory at best. The government know very well that they can bring forward regulations which we cannot amend, and they can bring forward regulations knowing that the normal practice of this House is not to vote them down on a fatal motion. How is that democratic? How can it be democratic that one of the houses of Parliament is unable to express its view in relation to the substance of this matter? And I agree.
The noble lord, with respect, no one is trying to stop this chamber on this or anything else expressing its view. What it's trying to stop is the assumption that it's this chamber that makes the final decision. It is not. It is essential for the maintenance of the constitutional arrangements we have that we always respect the elected House, who, as my noble colleague said, has to own those policies because they are directly responsible to the electorate. So it's not about discussing, it's not about revising, it's about who takes the final decision.
Well, I totally understand that. And it's customary in this House to ask the other place to think again. And I'm not suggesting that we should have the final word. I'm suggesting that tonight we should vote down these regulations and ask the other place to think again and to consider whether they really think it appropriate to proceed by way of what we all agree, Lord Coker said it, is a constitutional outrage. There are occasions where we have to stand up for constitutional principle, and this is one of them. If they send it back again, then no doubt we will give way, because they are the elected House. But we're entitled, I suggest, to express our view in an effective manner. It's all very well regretting, but it has no effect whatsoever. I agree with the comments of my colleague, Tom Hickman QC, and his co-author Gabriel Tan. Well, can I just finish this point? In the blog that they put on the website of the UK Constitutional Law Association, they said, and they're right, that the government is seeking to obtain through the back door of Parliament what they have been denied at the front door. It is, they say, a remarkable act of constitutional chutzpah, and they are absolutely right. And it doesn't stop there, because, as Lord Hunt rightly said, the explanatory memorandum to these regulations, I've not seen today's amended, improved version, but the original explanatory memorandum nowhere mentions, as Lord Hunt said, that these amendments were defeated when proposed as part of the Public Order Bill. And it's worse than that, as Lord Hunt knows, but it's astonishing that the explanatory memorandum at paragraph 3.1 under the heading, I quote, matters of special interest to Parliament, matters of special interest to the Joint Committee on Statutory Instruments, unquote, had this entry, none. Is that not extraordinary? Does it not demonstrate the contempt which the government has in this context for the proper processes of proper legislation in these matters? Yes.
I've only been here 4 years and I'm still learning. And Noble Lord said earlier that this statutory instrument, if voted down, could be, the other house could be asked to think again and they could bring it back. I thought my understanding is that a statutory instrument can't be brought back.
Well, you can't.
The new statutory instrument at any time they like. They're perfectly entitled. Yes, they can table a statutory instrument and invite us to consider it. Or, of course, far better than that would be to produce primary legislation, primary legislation which we can debate properly, which we can amend if we think it appropriate to do so, and which will then go back to the other place for them to consider. And if they don't agree with us, as the noble Lord Reid rightly says, we will follow, I'm sure, our customary practice and give way, because they are the elected house. But what is so objectionable about this is that all of those procedures are removed, that all we can do, it is said, is express regret. We're very sorry about this. Well, I express regret that the Labour front bench is not prepared to see through the implications of their own view that this is a constitutional outrage. It is something that we should stand up against and we should vote against.
My Lords, with very little exception, I agree with what the noble Lord Panic has been saying. I start with having very considerable sympathy with the motives that have caused the government to come forward with this statutory instrument. However, and for the reasons that were advanced by the noble Lord Coker, I do feel that the process is very defective. And however, again, for constitutional reasons, which I shall mention very briefly, I cannot support the fatal motion. Now, that in summary is my position, and if I may be given, I shall elaborate it a little further. So far as the motives of the government that lie behind the statutory instrument, I share very many of the views. Indeed, so does the noble Lord Panic. In a free society, individuals do have a right to demonstrate. However, their fellow citizens have a right to go about their daily business without unreasonable obstruction. And I do fear that increasingly we are seeing on the part of demonstrators a disregard for the obligations that they owe to their fellow citizens. So I can well understand the motives that activate the government in bringing forward the changes contained within the statutory instrument. However, and for the reasons advanced by the noble Lord Coker, I do have very real reservations about the process that is being adopted. A process, and the defects were identified by my noble friend Lord Hunt of the Wirral. He's entirely right. And his report is extremely direct on the subject. The statutory instrument is in fact designed to reverse the changes that were defeated in this House earlier this year. Now, if that is a desirable thing to do, it should be done by primary legislation. That is the point made by the noble Lord Paddock. Amendments made by this House on the report stage of a bill can always be considered further in the House of Commons and, where appropriate, be the subject of ping-pong. That is the proper way forward. A statutory instrument is an unamendable legislative device, and it is, in my view, one that should not be used to make significant changes to the law, and in particular to the criminal law. And so one needs to go to the purpose of this statutory instrument. And the Home Secretary, in yesterday's debate in the House of Commons, set it out. At column 55, she set out the 4 purposes of the instrument. At column 74, she said this: "We are trying to clarify the thresholds and the boundaries of where the legal limit lies, so that the police can take more robust action and respond more effectively." Now, that raises at least 2 pertinent questions. Either this statutory instrument, in effect, does no more than to tidy up existing legislation and ensure that existing case law applies equally across the statutory waterfront, or it is intended to make significant changes to existing law. In the first case, it must be doubtful whether the statutory instrument is required. In the second place, if the statutory instrument does make substantial changes to existing law, which is what I suspect, it should be done by primary legislation. And that is what this House intended to do in January. So finally we get back to process, which I think is fundamental to tonight's debate. I share all the reservations expressed in the noble Lord Coker's amendment, and they constitute, in my view, good reasons why the procedure adopted by the government is flawed. And I would like to think that if Lord Coker's motion is passed, and I will in all probability vote for it, the government would withdraw the statutory instrument and resort to primary legislation. However, I'm afraid I cannot support the fatal motion moved by the noble Baroness. And here I find myself very much in agreement with the views expressed by the noble Lords, Lord Reid and Lord Rooker. The House of Commons passed this statutory instrument last night by a very substantial majority. The fatal motion has a much more dramatic consequence than those occasions when the House amends a government bill. In such cases, the bill can be further committed and considered by the Commons. However, if this House carries the fatal motion, the statutory instrument is killed. And I believe that that does go beyond that which an unelected House should in general do. Of course I give way.
I'm very grateful to the noble Viscount. The noble Lord seems to be saying that the difference here is that if this House votes down a measure in primary legislation, it goes back to the Commons to be reconsidered. That is not what happened in this case. In this case, the amendment was introduced into the House of Lords, not in the other place. We voted it down, and it disappeared. It did not go back to the other House. Exactly the same thing will happen tonight if people vote if noble Lords vote for the fatal motion.
I entirely understand this point, but I do think that we need to draw a distinction between amendments that this House makes on committee and report stages, where it is possible for the House of Commons to consider again and come back to this House. And may I just finish this point, and then, of course, and in this particular case, where if we pass a fatal motion, as advocated by the noble Baroness, we will in fact be killing a statutory instrument, which last night was opposed but was supported by the House of Commons. And I am very, very unwilling to support that proposition as a precedent. And I agree with the views expressed by the noble Lords, Lords Rooker and Lord Reid. And may I say, may I just finish this, and of course I'll give way. And I say what I have just said. As one who was in the House of Commons for 30 years, I'm under no illusion as to the nature of the House of Commons. My father used to speak and write about the elective dictatorship. He was entirely right. But at the end of the day, we do have to decide where authority lies. And however imperfect authority may be down the road, it does have the authority of an election, and we do not have that. And I give way to the noble Lord if he wishes to intervene further.
I'm very grateful that the noble Viscount makes another error in his assertions. This was not an amendment introduced by the opposition to the bill in this House. It was a government amendment that was introduced in this House that was defeated by this House, which means that that amendment could not be then considered by the House of Commons. So therefore, there is no practical difference between the voting down of that government amendment, killing it completely, and voting for a fatal motion on this statutory instrument, which would kill it completely.
I'm not because I do think that the noble Lord is cavilling at this point. We are, in a sense, talking about principle. Where does authority, in the end, lie? It lies down there, because they're elected. It doesn't lie here, because we're not elected. And it is for that reason that I shall vote for the amendment motion moved by the noble Lord, and I don't feel able, although I agree with a great deal that the noble Baroness said, to vote for the fatal motion.
Thank you. I fear I may be ploughing a lonely furrow tonight in supporting the draft regulations and speaking to the noble Lord Coker's regret motion and against the noble Lady Green's fatal motion. Beg your pardon. Baroness Jones of Milsicombe. Beg your pardon. I have, in fact, read her round-robin email and the accompanying legal opinion, and we have discussed these regulations. And, of course, I've read the Secondary Legislation Scrutiny Committee report. I won't dwell on the process or the constitutional issues as such. I think the latter have been very well encapsulated by the nobles Lord Reid and Rooker, respectively. But I don't agree with Lady Jones's catastrophist rhetoric on this being somehow a constitutional crisis. I think the statutory instrument is quite simple and straightforward in seeking to strike a balance between freedom of speech, freedom of protest and assembly, and the rights of the public to go about their daily business unhindered and unmolested. It is also about legal clarity, both for frontline police and for the courts. The upsurge of large-scale disruption is not something that any government can ignore, especially as the effectiveness of and the public perception of the police will be impacted by operational and legal uncertainty. As of last Thursday, as the Minister said, £4.5 million has been spent diverting local policing priorities, equivalent to over 13,000 shifts, away from theft, from burglary, from violence against women and girls, of knife crime, etc. 86 arrests and the bureaucracy that involves, mostly for breaching Section 12 of the Public Order Act 1986. Every government has a responsibility and a duty to protect its citizenry. And let's remember, the police are currently in a very difficult an unenviable position, because slow walking doesn't just have an impact in a confined geographical area, but in a wider community and economic sense. And in terms of the effect on working people, on businesses, on public services, emergency services, hospital appointments, funerals, etc. And at the present time, the police have to balance the rights of protesters to exercise their rights under the Human Rights Act and the European Convention of Human Rights, and the impact of taking time to consider these competing interests leaves the police open to charges of partiality, bias, weakness and incompetence. And such a situation quite obviously gives rise to anger from the most affected by their selfish exhibitionism, often enacted to garner social media coverage, and to vigilantism. And that causes, of course, further public order incidences. It's unrealistic not to imagine that such a situation arises not from a single event, but from cumulative and repeated events and actions, perhaps over several days, which are more than minor events. And I would posit that giving police different, not enhanced powers to close down demonstrations more expeditiously are in the public interest more widely. The regulations do not create new powers, but make existing powers clearer and policing more consistent. And, my lords, it's important to remember that they also align, as the Minister said earlier, the threshold of serious disruption with that in the Public Order Act of 2023, a definition arising from recent case law. And as such, the Government is right to use the delegated powers in sections 12 and 14 of the Public Order Act 1986. Like policing, governance is best undertaken not just by democratic accountability and authority, but by consent. Quite evidently, the wider public is demanding that ministers tackle the problem of deliberate and willful disruption, actions that do nothing materially to change policy, but also do not persuade sceptical citizens, but is in fact punitive and pointless in equal measure. And I don't believe this statutory instrument is a radical departure and sets a dangerous constitutional precedent. It is certainly not, for instance, a draconian assault on freedom of speech and civil liberties. And comparisons with the suffragettes that I think have been used by some members of the Green Party are specious, of course. We have had universal suffrage and universal suffrage elections since 1928. It might be appropriate, my lords, to turn now to some of the criticisms and observations in the committee report. As I wind up, on consultation, I think it's unreasonable to expect the Government to undertake a comprehensive consultation process when the imperative is to correct quickly a legal loophole. I do have sympathy with the late tabling of these amendments at the report stage. I think that's a very fair point to make. Let me finish with the words of Lord Hoffman. Lord Coker, the Noble Lord Coker, talked about the importance of conventions. And with this in mind, Lord Hoffman said in 2006, civil disobedience on conscientious grounds has a long and honourable history in this country, but there are conventions which are generally accepted by the lawbreakers on one side and the law enforcers on another. The protesters behave with a sense of proportion and do not cause excessive damage or inconvenience, and they vouch the sincerity of their beliefs by accepting the penalties imposed by the law. The police and prosecutors, on the other hand, behave with restraint. And this is what this regulation is about.
The merits of the policy which this proposal purports to, or would, introduce. It is the manner in which the Government have proceeded which, like my noble friend Lord Panic, causes me great concern. The Home Officers behaved in a way which I think I can find no kinder word to use than disreputable. For a start, the explanatory memorandum, whichever edition we're in now, didn't mention the fact that the proposal had been rejected by your lordships. And when the committee quite rightly inquired why this was not mentioned, The reply could have won an Oscar for weasel wording. The details that have been included, it said, are those which we considered relevant to the document. When you're caught bang to rights, the proper response is an apology, not an obfuscation. Yet more astonishing, and the noble Lord Lord Panic has already referred to this, is that in the section of the explanatory notes outlining anything which might be of interest to Parliament or the JCSI, the single word none appears. Then there is the question of consultation. The Home Office ignored the government's own consultation principles and consulted on a selective and skewed basis. It brought to mind the Sellers and Yeatman description of a passage in Magna Carta which they alleged said no baron should be tried except by a special jury of other barons who would understand. In this case, the Home Office set out to consult a selection of people they knew would support them, not those who might have a different view. A kind description would be that this was not straightforward. Tom Hickman, KC, and he's already been mentioned, the Professor of Public Law at UCL, has pointed out that where a public authority chooses to conduct a consultation process, that consultation must be conducted properly and fairly. And he points to a ruling by the Court of Appeal that a consultation conducted before certain COVID-19 regulations had been unlawful because it had been conducted on an entirely one-sided basis. I do not see how the consultation carried out by the Home Office in this case could be described as proper and fair. This instrument and the explanatory memorandum, again, whichever edition you care to quote, must have been signed off by a minister. I think we might be told which minister it was, and which minister took the view that this was an appropriate way to treat Parliament. And I hope that the noble Lord, the Minister, will be able to tell us. And I don't want to see, and I'm sure your Lordships don't want to hear, any pabulum about collective responsibility. I suggest earlier that I do not take a view about the merits of what this instrument would achieve. My concern is for the way in which Parliament is being treated and for the apparently resentful and sullen way in which the committee's questions have been answered. I am sorry, and I do understand what the noble Lord Lord Coker was saying earlier on, that His Majesty's opposition do not wish to go further than regretting what is in front of us. Governments shrug off regrets. They make no difference. As the noble and learned Lord, Lord Judge, said in the Queen's Speech debate last year, if we make no difference, why do we not just go on talking? I should tell your Lordships, incidentally, in my recent email conversations with the noble and learned Lord, we have focused on England's chances in the Ashes. And I know that we all sent him our warmest good wishes in his convalescence. This brings me finally to the fatal motion in the name of the noble lady Baroness Jones of Molescombe. And I think at this point it's very important to recall that it is a very easy thing for a government to withdraw an SI, redraft it and relay it and start the process again. It is also, and of course the business managers will balk at this, but nevertheless it's not that difficult to achieve a change by primary legislation in a relatively short time. And as some noble lords have made the point, that is actually the right way to proceed. It's not just what you want to achieve, it is the propriety of the means you use to get there. So that fatal motion, if we don't want this sort of thing to happen again, we should vote it down. And if she presses the matter to a division, I shall support her.
Can I just ask him a question? And the question is, with all his decades of experience of parliamentary procedure, has he ever seen a set of regulations that so defies constitutional propriety?
I think the noble Lord will know the answer, and it is no.
Can I start, my lords, by joining Lord Coker in the comments that he made about my beloved home city And if I could also pay tribute to the Nottinghamshire Police and all the emergency services in their responses to the dreadful events in the city today. And clearly I send my condolences to the friends and families of those who were dreadfully murdered. I think I should also start by saying I do very much understand some of the frustration that has been expressed in the debate so far today, whether it's come from the noble Lord Coker, my noble friend Lord Hunt on behalf of the committee, or indeed other points that have been made during the various speeches that we have had. And it is important that the government produces good quality explanatory memorandum. I think it has not covered itself in glory in this particular situation. And I care about procedure, I do very much. But I also care very much about the way in which this House conducts itself and the relationship that we have in this House, between this House and the Executive. And I feel that over the last few years it has deteriorated. It has become increasingly hostile. I think that that has been evident clearly in the way in which some of the debates we've held on a range of different legislation have occurred. And sometimes we have made our points in ways which have not showed any sense of disrespect to the government, because that's not for this House to worry about whatsoever. But sometimes we have conducted ourselves in a way which I feel has shown disrespect too often for members of the public who take a particular position on things which some of us may not agree with. So I do think, as much as this debate is about procedure and it is about good order, I think if we are to move beyond the situation that we seem to have got ourselves stuck in terms of how we are dealing with some of these difficult issues and some of the ways in which the government is bringing forward its legislation, not necessarily always as good quality as it needs to be, or whatever, and the way we're reacting to it. If we're going to move on from this and to be, in my view, even more effective in discharging our responsibilities as the second chamber of Parliament, I do think we have to also look at the bigger picture when we are considering today's issue which is before us. And just before I move on to the bigger picture, on the points of some of the points of procedure that have been raised, I think what my noble friend the Minister did quite clearly in introducing this debate was to set out that actually the situation that we find ourselves in respect of this particular piece of secondary legislation isn't quite as straightforward as some noble lords are trying to portray in their opposition to this particular procedure in this context. Because, as I understand what he was saying, some of the substance that appears in this secondary legislation did go into the relevant piece of primary legislation, but it didn't go in a way which was consistent across the piece. And we have this very unsatisfactory situation now where there is this lack of consistency for the police in them being able to uphold and meet the various responsibilities that they have. So I think that needs to be understood and remembered. It is not as if the government has come forward with a piece of secondary legislation to try and introduce something which has not already been featured in the legislation. And to the point in the exchange that has occurred between my noble friend Lord Hailsham and the noble Lord Paddock, it's important also to understand that the amendment in the primary legislation that was rejected was a government amendment, that's quite right. But in ping-pong, it is not possible for the government to reintroduce an amendment down there when there's not the possibility for them to do so. So we're in a very, very different kind of situation. So the reason why I lay all that out is because I think that some of the arguments against what the government is trying to do here don't quite add up. And so when it comes to the substance of this piece of secondary legislation and what the government is trying to do via here, I do think we have to concentrate on that rather than just on the procedure. And we hear a lot in our debates about the importance of various human rights or various different things which are important to uphold in the context of peaceful process. All of this is very important, but they are not the only essential ingredient to a healthy and cohesive society. Common standards and social norms are critical to underpinning our communities. And when we look back to 2019 and the events of that summer, what we saw was a completely new way of protesting in London. London was brought to a standstill for 5 whole days. Now, I'm pleased to hear today that the Noble Lord Coker, or the Noble Lord Panic, criticise that form of protest and to make clear that it is unacceptable. But what we also have to remember is that we didn't do that in 2019. We had a situation where for several days Waterloo Bridge was closed and our police were not doing anything about it, and a lot of us in positions of authority were supporting that situation because we were sympathetic to the cause of the protesters. Now, what a lot of our fellow citizens felt at that time was completely confused and let down. And they couldn't understand why we found that acceptable. Now, since then, of course, we've had a range of different legislation brought forward by the government trying to deal with these matters. And as we've heard, during the course of them trying to pass that legislation, it has become increasingly tense, increasingly hostile, and we've got ourselves into a situation where the laws that we've passed are offering more complexity than they should be to the police, so the police can do what our fellow citizens want them to do, which is to make sure that when protesters are out there and are bringing our roads and our cities to a standstill, that they act swiftly, that they do what is expected of them straight away, and they don't create a situation where people feel it is necessary to take the law into their own hands, and in doing so, they then attract the criticism of the police. So, my lords, all I want to say is our inaction and our unwillingness to stand up and call out this in 2019 has consequences. The consequences are of legislation. We have tried to pass that legislation, or the government has tried to pass that legislation in as straightforward a way as they possibly can, and it has been proven to be incredibly difficult for all sorts of reasons, as we have heard and discussed in the course of this evening. But I do think that if we, as I go back to where I started, if we believe that actually there is an opportunity for us as a House to show that we really do want to respect and show that we are on the side of the law-abiding citizen who wants this clarity, then I think tonight I would very much support my noble friend, the Minister, in following him through the division lobbies. And I hope all noble lords will do this.
My lords, Baroness Stow of Beeston raises some important, broader questions to be considered. But I think that she's actually overcomplicated what is a more straightforward problem that we have. When I heard about this particular set of instruments, which after all, were brought in by the government into this House at report stage, which was extraordinary enough as it was, and lost, and then you find them, they've come back again, and then we're told, well, they have to come back again because something really dramatic has happened. There's been a whole new change of circumstances. The police haven't got the powers to police this really difficult situation. And then you find out what the new tactics are, and it's basically a load of people walking slowly in the middle of the road. And you do think, well, why don't the police just arrest them then? They've got a huge amount of power under public order. I was speaking at a meeting the other night, and somebody said, what are you doing? Why are the police not using the highway code to actually stop people walking slowly down the middle of the street? It makes no sense that the only way that the police can deal with this is to bring in a statutory instrument that goes against completely, constitutionally, the way that the law should be made. I do think there's a very serious danger that the law, and secondary legislation in particular, is being used because there is somehow a failure of the police to police, a failure of the government to ensure that the police police. And if you want to know the frustration of all this is, while the police say we haven't got the powers to stop people marching slowly in the middle of the highway, in the road, blocking everyone off, they suddenly spring into action rather quickly as soon as a member of the public gets frustrated and starts pulling down the barriers and drag that person off and put them and arrest them and so on. So you can see that there is a mess here. That's basically it. And I think the government have made that worse, and I think that using law in this way is discrediting in every possible way. But despite all of that, and my instincts, and all the way through the whole of the bill, you know, my instinct is, as I saw somebody waving a placard at me on the way in, you know, kill the bill. And I actually agree. This bill, I want this bill to go away, right? I'd love it. I know it's not a bill, that's an act. But I would love the act to disappear. I hate everything about a lot of the things that were brought in on that policing bill. Any civil libertarian does not want to lose liberties in the way that I think that we did. I agree with all of that. However, and I know, by the way, that Baroness Jones, take her at her word, Baroness Jones at Mulscombe has said that she has not brought in her fatal amendment lightly. She's lost sleep over it, and I think that that's fair enough. She's doing what she thinks in good conscience. It's just that, in the end, if the government are behaving constitutionally irresponsibly and tearing up conventions, I'm not prepared to imitate them. As far as I'm concerned, in the end, the only way that we can actually, in good conscience, behave is to condemn the government for what they've done, call on the government to get the police to do their job and stop using the law inappropriately in the way that they are, but ultimately express our regret, but not imitate by actually unconstitutionally ourselves asserting in an unelected chamber that we overthrow the elected House. I, by the way, so often disagree with the elected members up the corridor, it's boring. But who cares what I think? I am here not through the electorate or the public. We are all here because somebody put us here. And goodness knows that's a controversial enough matter. And goodness knows we have no more legitimacy than somebody somewhere thought we were a crony at some point. Well, they made a mistake there with me, let me tell you. But anyway, let me just say, we should not, I'm afraid, put a fatal motion through. This should absolutely, however, be condemned through the regret motion, and I support the Labour amendment, and I will be voting.
My Lords, I'd rise very briefly. Everybody would be grateful to know. First of all, I intend to support Lord Coker's regret motion, because I think it's the right thing. I think the arguments made by Lord Reid and Lord Rooker are profound, and I think it's the vote last night was clear. The Commons had their chance to get rid of it. They didn't. So for that reason, and also on content, I just wanted to remind us of just one thing, because Baroness Cox's comments made me particularly feel it's important to remind us. All the criticism of the police has been in the past. They've done too little when protesters have been doing too much. And they've not done that just because they were being incompetent, although some may argue they were. But they did it because the Supreme Court made a decision a few years ago which left them with some dilemmas. It said that obstruction of the highway is not merely a simple offence anymore. Obstruction of the highway requires no intent, no recklessness. It's an absolute offence. You either block the road or you don't. But the Supreme Court said, no, you've got to consider far more than that when you make a decision about arresting someone. Have you got an alternative route? Have you got another thing you could do to avoid this obstruction? Well, that's fine if you've got a planned protest. It's not if at 5 o'clock this afternoon, some poor inspectors confronted with a problem has got to resolve it. So that's why this Act, I think, has been really important. And I think part of this conclusion is about the definition. I agree entirely that this is the wrong way to include this definition. I don't think anybody's argued it's the right way. I don't think even the government has argued it's the right way. So that's why I support the regret motion. But I think to provide more lack of clarity for the police is likely to lead to more problems rather than less. And the reason was not just about the lack of clarity from the Supreme Court decision, it was because of some of the protests that were taking place and the disruption they were causing. Around Heathrow, around many of the significant things we all need to keep our people safe and secure, and in fact the law was being abused in a way that was hurting too many people. So for all those reasons, with the regrets mentioned in the motion that Labour put forward, I will support that motion, but I can't support Baroness Jones, although in my humble view, it was the most powerful speech she's made while I've been here, although I'm sure there have been other opportunities that she's taken that I've not seen.
Helen Hammond. Go on, Helen.
Extremely grateful to the House, and I will be very brief. But no one has mentioned the last time we had a debate with great passion on the issue of statutory instruments and voting them down in 2015. I was torn on that occasion between what was a rather elegant delaying motion rather than defeating an SI and the standard regret motion. And I find myself in a very similar position now. I won't go and repeat the constitutional outrage that I think this statutory instrument is. And I won't repeat the arguments for maintaining the precedent, the protocol, and the conventions of this House in not defeating statutory instruments. But I do think this cannot go on forever. The situation regarding statutory instruments is unacceptable. It's 40% of our legislation. And what they are actually, it's not legislation, they are executive orders. They are executive orders that come before Parliament. And I hear my friend, Lord Rooker, my friend, Lord Reid, talking passionately about the supremacy of the House of Commons, with which I passionately agree. But Lord Rooker talked about what we can do is ask them to think again. We can ask them to think again and again and again, because we can push that forward. But we cannot on these executive instruments. We cannot on statutory instruments ask the government to think again. We cannot amend them. We cannot delay. It's take it or leave it. And that is not a satisfactory way to make legislation on issues as complex and nuanced and difficult to resolve as the issues that we are facing today. For that reason, I think that what I would like to see out of today's debate is a shared understanding. I don't think anyone, other than the Minister, God bless him, has suggested that this has been a satisfactory process. I think it's been a disgraceful process. What we ought to do, I think, is take away from it a real conviction that we need to look carefully and to change the way in which we deal with statutory instruments.
I agree. I agree.
My Lords, we on these benches associate ourselves with the remarks of the Noble Lord Coker on the tragic events in Nottingham. And like the Noble Lord Panic and the Noble Lord Lisvane, I don't want to say much about the substance of the SI. If the Home Office had realised that the 1986 Public Order Act needed to be amended before the bill had left the other place, we would not be here now. What I want to talk about is the constitutional issue described by the Noble Lord Hunt of Wirral, of a government changing primary legislation by means of secondary legislation within months of this House having voted against that primary legislation. As we have heard, this is unprecedented, or, as the Noble Lord Panic put it, a constitutional outrage. My Lords, on Monday, this House will have the second reading of the British Nationality Regularisation of Past Practice Bill. This piece of primary legislation retrospectively changes primary legislation by means of a two-clause, fast-tracked piece of primary legislation. Not only is this the proper way of amending primary legislation, it also shows that it can be done quickly and easily. There is no need for the will of this House, expressed through a recent division, to be overruled by means of secondary legislation, when a single clause fast-tracked bill could have done the same job without creating an unconstitutional precedent. Noble Lords opposite may say it's no big deal. But the Prime Minister said his administration would have integrity, professionalism and accountability at every level. I'll return to the integrity issue in a moment, but failing to amend the 1986 Act in the other place clearly shows a lack of professionalism. And failing to correct the mistake by means of primary legislation shows a clear lack of accountability, because as the Noble Lord Panic has said, scrutiny of secondary legislation is cursory. On the integrity issue, on the Boris Johnson resignation honours row, Michael Gove, a senior government minister, said on the BBC Radio 4 Today programme yesterday, on the 12th of June, and I quote, "The appropriate procedure was followed." He went on to describe it as, and I quote, "a process we are all familiar with as part of the Constitution." He went on to say, "It is appropriate to look at all these processes. They all have their own coherence in accordance with past practice and due process. All governments work according to precedent," he said. He went on to say, those are protocols that govern this particular procedure, and I think governments overall have been criticised sometimes for departing from due process. I think it was appropriate and right that the Prime Minister and the government followed due process in this way. He went on to say, "I know it's old-fashioned to want to use precedent and independent institutions to establish how all these sorts of things should be decided, but then precedent and independent institutions are, I think, the two of the constitutional bulwarks that are important," unquote. My Lords, this House is an independent institution, and this SI breaks long-established precedent. In order to answer a question about changing precedent in connection with resignation honours, Michael Gove said, and I quote, "The inference of the question is that we should alter precedent, and that we should in some way say to independent institutions that they should operate in a different way from which they have been constituted. I think what we have here are the existing constitutional machinery working as it was designed to do." So, my Lords, there we have it. A Conservative government that believes that independent institutions should not operate in a different way from which they have been constituted, and precedent should not be altered, but only when it suits them. That, my Lords, is the very definition of a lack of integrity. My Lords, this House voted against the provisions in this statutory instrument by a majority in a division on primary legislation in February this year. There is no precedent to overturn a decision of this House on primary legislation by means of secondary legislation. I'm reminded of the words of the noble Lord Forsyth of Drumlee when he, in the debate on the illegal immigration bill on the 10th of May, column 1801, addressing the motion to deny the bill a second reading, which he considered to be unconstitutional, and I quote, "I do not think any member of this House who respects its values and its role could possibly go through the lobbies and vote for that amendment." Let me adapt his words and apply them to this situation. My Lords, I do not think any member of this House who respects its values and its role could possibly go through the lobbies and vote to allow this statutory instrument to pass. I say to the noble Lords on the Labour benches, you will be complicit in undermining the status of this House if you do not vote for the fatal motion. The noble Lord Coker says the official opposition will respect convention and not vote for the fatal motion. But my question to him is why, when the government have not respected convention? And to the noble Lord Reid and the noble Lord Rooker, of course it's right that the other place should have the final say. But if we vote down this statutory instrument, the other place can introduce a one-clause bill of primary legislation in order to achieve exactly what this statutory instrument is trying to achieve in an unconstitutional way. And I say to the noble Lords on the Conservative benches, is, as appears ever more likely with each passing day, there will be a change of government at the next general election, you will be creating a precedent that you are likely to regret for many years to come, when the incoming government uses this precedent to undermine the will of this House in the future. We will vote for the fatal motion.
Yeah, very good. My Lords, I'd like to thank all noble Lords for their contributions to what has been both a fascinating and obviously powerful debate. And before I start my response, can I also join in the noble Lord Coker's remarks about the situation in Nottingham, thank the emergency services as he did, and obviously express our sympathies and my sympathies to the victims and their families. My Lords, I'm obviously going to refute the allegation that this is in some way unconstitutional, or indeed an outrage. I've already set out why the government has brought forward the measures and the fact that it is indeed proper. The sequencing of debates and votes during the passage of the Public Order Act of 2023 meant that the House of Commons were unable to consider the measures. Now that the elected House has approved the measures, we must respect their will and do the same, a point that has been made powerfully by a number of noble Lords. My Lords, the government, the delegated power being used existed prior to the introduction of the Public Order Act of 2023. The power was available for the government to use during the passage of the Public Order Act 2023, comments I made in my opening speech. And those powers were scrutinised by the Delegated Powers and Regulatory Reform Committee, who recommended that a definition of serious disruption to the life of the community be included on the face of the Police, Crime, Sentencing and Courts Act 2022, coupled with a power to amend the definition by affirmative procedure regulations. And this recommendation was accepted and implemented in full. It is entirely right that the Executive uses powers conferred by both Houses of Parliament to allow the elected chamber to consider the proposed change in law. The other place has now had that opportunity to consider these measures and have approved them following debate on the floor of the House. So this is not defying the will of Parliament, as some have suggested, or indeed, as I said earlier, committing a constitutional outrage. As the noble Lords Reid and Rooker have pointed out, we are actually respecting it. This cannot be sent back. So to not do this now would be to enshrine a lack of clarity and consistency, as my noble friend Baroness Stoll noted, in protest law. That will affect the police, the public, and of course the protesters themselves. Any delay in what is obviously a fast-moving situation risks, as I pointed out again in my opening remarks, to continue to encourage the public to take matters into their own hands, a point that I think was very well articulated by my noble friend Lord Jackson. I would say to the noble lady Baroness Fox, who, as she knows, I respect greatly, that this is enabling the police to do their job with more clarity, a point that Lord Hogan Howe has also made with considerable force. My Lords, my noble friend Lord Hunt asked some very sensible and, if I may, searching questions about the explanatory memorandum, which I'd like to address. I would say to the noble Lord Lisvane that the government published the explanatory memorandum and the government has updated it. The primary focus of an explanatory memorandum is to provide clarity on the content of the statutory instrument's provisions. Additionally, the vote excluding the similar measure from the Public Order Act was only held earlier in the year. All the information on the vote is obviously readily available on Hansard. That being said, we do recognise the Secondary Legislation Scrutiny Committee's criticism and the importance of transparency in explanatory memoranda. So I can confirm, as has been noted, that the updated memorandum has been published. It wasn't published before the debate in the House of Commons, but I have to say that the changes to the explanatory memorandum are relatively minor. They do not add new information. They reference the votes and clarify the extent of targeted engagement and are in direct response to concerns raised by the Secondary Legislation Scrutiny Committee. The Home Secretary also set out clearly in yesterday's debate in the other place. My Lords, in terms of the consultation, which is obviously another subject that has been raised, and again, if I may, I'm afraid I'm going to have to refer back to the opening remarks. This statutory instrument does not create new powers. The government has always been clear that the delegated powers were needed to be able to quickly respond to the evolving protest tactics. And as they don't grant new powers to the police, but just clarify the extent of existing powers, it was deemed disproportionate to carry out a full public consultation. Targeted involvement with the National Police Chiefs Council, the Metropolitan Police Service and other police forces was the appropriate approach. All have welcomed clarity in the law. And the Metropolitan Police Service specifically welcomed clarity as to how the police should consider serious disruption in relation to imposing conditions. My Lords, the noble Lord Coker suggested that there were new powers being created, and I think he referenced the Chief Constable of the Greater Manchester Police. As I have mentioned, these measures, and I have to stress this, do not create new powers, but they clarify existing ones. And the Commissioner of the Metropolitan Police Service, the force most affected by protests in England and Wales, has asked for further clarity in the law. I think it's very evident from the events that we're seeing at the moment how significant and necessary that clarity is. My Lords, I don't think there's really very much point in me saying very much else in answer to the questions. I do think I've addressed the majority of the issues that I didn't address in my opening remarks. As I said earlier, I am grateful for the constructive and helpful questions. I will obviously take some of these reflections back to the department and indeed to my noble friend, the leader of the House, who's not sitting here at the moment. These regulations obviously are designed to ensure public order legislation is clear, consistent and current. They will also support the police in striking the correct balance between the rights of protesters and the public. And I beg to move.
My Lords, can I thank everyone who's taken part in what has been an interesting debate. Can I just start by just saying to Lord Jackson that nobody's saying anything, and I'm not going to debate, I just want to say, but nobody's saying that the current protests that we've seen are acceptable. We all agree that something needs to be done about that, and that's unacceptable. What the whole debate about the protests bill before us was what is the appropriate way for the state to respond in balancing the right between protesters and the public. And what my contention is that the government, through the secondary legislation, is changing the various measures that we only just passed in the Public Order Act as it is now, are changing certain things by secondary legislation, including, for example, changing the threshold that Lord Hope referred to, where more than minor was just linked to the particular offences of tunnelling and locking on. Indeed, I got rebuked when it was said that threshold was too low and we should have a higher threshold. I was rebuked when it was just said to me, well, this only refers to the offences of locking on and tunnelling. And as Lord Hope says, what the government have done, and they actually pray in aid, Lord Hope, who we've heard is very unhappy with the process, what the government have done is extended that. That's what this is about. No opportunity for anyone in this House to say that that is inappropriate in a way of controlling protests. Nobody can say that that threshold is inappropriate. We just have to accept it because it's done by secondary legislation and is unamendable. And that's the point. And then you come to the whole point of process, which is the point of my regret motion and the point of debate between us all in here. There are choices before us in how we respond to the fact that the government has driven a coach and the horses through the way that parliamentary democracy in this country works. There is absolutely no question that that is what it is done. The Convention does not say that you change primary legislation by secondary legislation. The Secondary Legislation Committee says that they can't find another example of that being done. Well, if you can't find another example of that being done, it probably means that the convention is you don't do it. And therefore, the convention must be that if you want to significantly change legislation with respect to protest, you do it through primary legislation. So I would think that is the majority, apart from one or two people shaking their heads at me, which is fine. But what the challenge, therefore, that's before us is how do we respond to the fact that the majority of people, I would suggest, in this place think that the government has acted inappropriately in the way that they've dealt with this particular issue. That's the question. And you can say you should do nothing about it. It doesn't matter. The Tory whip will say, pour in, vote down Coker's amendment, support the right to lock all these stop the oil people up. It doesn't matter. Convention doesn't matter. The way the Constitution has operated in this country doesn't matter. Pour in, just vote it down. He'll shut up in a minute, it's fine. I tell you, it is absolutely outrageous what has happened. And I say to Noble peers opposite that actually it is an opportunity for the Conservative members of this House to abstain and to say that they actually accept that actually this is the wrong way of Parliament proceeding with respect to this. Don't just pour in. Don't just pour in and say it doesn't matter. It fundamentally matters.
The Noble Lord Coker is giving a customarily powerful closing speech. Would the Noble Lord at least acknowledge that it is not just, as he is alleging, the government that has driven a coach and horses through a convention over the last few years? It is Parliament in this House and down the corridor in the other place that has also done that. And my contention earlier is that it takes two to tango. And we have got to a situation here where the government is being forced to do things which are unconventional, but are doing that because of the way in which we collectively have had to conduct ourselves. So, and it would just be for him and I to both agree that we need to move on and we need to have a better way of conducting business than the way we have seen of late. It requires us all to reflect and not just for the government to do so, although they do need to do so. I do accept that.
That leads me nicely, I say to Baroness Stowell, onto the point that I'm making and trying to make. The Conservative peers have a choice to make as to how they respond to the way I believe that the government has undermined the conventions of this House by abstaining on the vote. I have a choice to make, and I'm saying to my party from the front bench that we should respect the conventions of this House by not voting down the will of the elected Houses of Parliament. That's why I'm being criticised for not actually supporting the fatal motion. As Lord Paddick has just said, Lady Jones has just said, they think I should be suggesting that to my party. I think that undermines convention, and I will not recommend that to His Majesty's opposition as a way of doing that, because I think that is inappropriate. That's the way I'm seeking to respect conventions of this House, by not suggesting to His Majesty's opposition that they oppose what the elected government of this country has put forward. What I'm saying, in as much as I have to accept my responsibility and my suggestion to how my party should vote in this, Lord Paddick will have his view about how he thinks his party should vote. Baroness Jones has outlined how she thinks that should vote. I'm saying to Conservative peers, they have an opportunity now, through the vote they make, to actually deliver what they think is their verdicts on how the government has operated with respect to the conventions of this House. And I contend they've driven a coach and horses through the conventions of this House, where primary legislation is not changed by secondary legislation. At its heart, that's what my regret motion is about, trying to respect the conventions of the House, whilst also expressing regret with respect to the way these public order regulations have been carried through. And at the end of the day, that's a choice that people will have to make. I've made my choice with respect to my party. I'm saying to them that we should vote against, abstain on the fatal motion, but we should support my regret motion. Others will have to make their choice. I hope they make the right one.
My Lords, the question is that the amendment in the name of Lord Coker be agreed to. As many of that opinion will say content. Content. The contrary, not content.
Not content.
The question will be decided by a division. I will advise the House when voting is open, and I would suggest noble Lords stay in their seats, because I will be up again in about 3 seconds. Voting is now open. Clear the bar. The question is that this motion be agreed to. As many of that opinion will say content?
Content.
The contrary, not content?
Not content.
The contents will go to the right by the throne, the not contents to the left by the bar. The question is that this motion be agreed to. My Lords, there have voted content 177, not contents 141, so the contents have it. Amendment, Baroness Jones of Moulscombe.
There's two ironies here. The first irony is that I don't think for one moment that this piece of legislation is going to catch any more protesters. I actually think that people who think they are defending the planet are very dedicated people, and they are very creative, and they will come up with other ways of protesting. And so this particular law is likely to catch other people. So that's an irony. And the second irony is that I, who complain endlessly about all the ridiculousnesses that happen here, and I'm very short of patience when I'm told not to run in the corridors and things like that, I actually am defending the status quo. I mean, that's an irony, that I want us to actually respect the conventions, and therefore I should like to test the opinion of the House.
The original question was that the motion as amended be agreed to. Since when a further amendment has been moved to leave out the words last inserted and insert the words as printed on the order paper. As many of that opinion will say content. Yes. The contrary not content. Not content. The question will be decided by a division. I will advise the House when voting is open, and you might wish to stay in your seats again. Voting is now open. Clear the bar.